Good evening, everyone. We got a full house tonight. We got me, Seven Man, Plutarch, and our guests John and Tom with the Family Government Institute. You guys want to tell us anything briefly about what you guys do?
Uh,
John, you want to take that?
well, we're just trying to establish the Family Government Institute. We have a lot of things in place, but I'm waiting for the IRS to respond to change. And once I get that going, we'll be ready to start building a website and that sort of thing and getting money.
All right.
So
So
I have a couple of questions, just background. So you guys
Yeah.
are Christians and approaching this from a Christian standpoint, correct?
Absolutely.
Okay. So on our channel, Nick is Orthodox Presbyterian, Plutarch is Presbyterian, I am Catholic, and so we kind of go back and forth. We see things from a different standpoint. So, what religious perspective do you guys come from?
I grew up Lutheran,
Okay.
and
Yes. Oh, I'm sorry. Go ahead, John.
well, I just grew up Lutheran, and like every college kid in America, you don't return to the church, but you find your way through
Sure.
life, and eventually you meet the devil himself, and you decide, maybe it's time to review things and examine. And I found God through the law, studying the law.
Okay. How about you, Tom?
Well, my family attended Methodist church, but we weren't regular attenders. And my father was pretty much not religious until his final
Okay.
days. And so I didn't really attend church much. I'd go on the holidays and things like that. But once I got kind of,
The reason I asked that is not to test out whether you're genuine or not. Just every, call it denomination or Catholic versus Protestant, we each have different terminologies and a different language and different definitions. So that helps me to know what definitions they're using because I grew up evangelical and then became Catholic. So I can kind of understand both languages and the definitions. And I find that a lot of the disagreements between different Christians come because they're speaking different languages or they have different definitions for words. And there's really no meaningful, real disagreements. But man, can things get heated?
well, that same principle applies to civil law. Certain terms have different meanings depending on the context in which they're used. And if you don't understand the original or the origin of the terms being used, it's easy to be misdirected into reaching a conclusion that's wrong about what the law actually says. And
also the law, even interpreting the law, those who use the law play word games.
I'm sorry, you kind of muffled a little
Yeah,
Nick, you're cutting out some.
Okay, so those who use the law, those who study the law and make laws, uh, whether intentional or unintentional, they end up playing word games.
bit. Right. Lawyers are wordsmiths, primarily. What we, okay, how do I explain this? I probably have to start with the Flint case. We always come back to that when John and I are talking the law and the problems with so-called family law. Because right there is one of those words that nobody truly understands what family law means or what family law is. And because family law. Well, we can pull up a slide on that just so we can
Okay,
discuss
which
that.
one? The
Let me-
this one?
The bubble
No.
one. That's the family law. The one next to that.
Oh, there we go.
Okay.
Oh, here it is. The merging of private domestic relations law with public child welfare law. The merging of them becomes family law.
Well, not the merging, it's the blending. They will take laws that deal with private domestic relations, like marriage, divorce. Um, well, in Minnesota, it would be called support money and alimony in divorce situations. Now, under the red bubble there, it um, deals with public, is the parens patriae power of the state, which is the state exercising um, parental authority over children who are dependent. In other words, they're dependent on public dollars to meet their basic needs. And that those basic needs are then met by the state pursuant to this parens patriae authority. And that is a public interest, which has a different standard than laws dealing with private domestic relations, which would be, well, master servant. That's really what a marriage contract is, because a man um, proposes marriage to a woman because he cannot have a child by himself. He needs a mate for that. That is the master servant relationship. And it's our contention that in exchange for that, this is why it's so hard to explain. The marriage contract allows what the woman can do without a man. Well, not without a man, but without marriage. She can have a child without marriage, and have this right to the custody of that child. Whereas a man, the only way he can have a natural right, or what we claim is now an unalienable right, to the custody of his offspring, is through the marriage to the mother of that child. And it's through the marriage. Okay, outside of marriage, an unwed mother would have the natural right to that custody. Through marriage, she transfers that unalienable right, which normally unalienable rights are by definition can't be transferred. It's our position that marriage creates an exception to that general rule. But she transfers that to the man through the marriage, and in exchange, she receives coverture. And coverture has been so demonized, it was one of the first things the feminists went after. Why? Because that coverture is actually a benefit to the woman. If she's guaranteed a lifetime of care and support from this man that she just gave what we have termed natural law guardian, that unalienable right to the custody of the child. It's similar to guardian by nature under the common law and guardian by nurture under the common law. It's kind of a combination of the two. Under the common law, guardian by nature only dealt with the heir apparent, the firstborn heir apparent, where a guardian for nurture applied to all the other children. But the man had was recognized as having this natural right to their custody and care and upbringing and education, religious and secular educations. And okay, where do I go from here?
So
Well,
we're talking
let
about
me jump in.
inalienable rights. We're also saying we're talking about inalienable rights. We're also talking about nature. So inalienable rights is part of the natural law. Is kind of what you're saying.
Okay, well, there's another one of those words. The difference between inalienable and unalienable is important. The word unalienable, as used in our Declaration of Independence, is not the same as inalienable when you are talking about a man-made or a man or positive law. Um, what's an example? Well, all unalienable rights are rights that come from God exclusively. Man can't create an unalienable right. They can create inalienable rights when they pass the Constitution. Your rights under the Constitution, they're all inalienable. But whoever crafted that Constitution also has the power to uncraft it. They can abolish it. They can write a new one. Whereas an unalienable right is unchangeable. No one can change that except God himself. That's an important. So when you read the way lawyers address it, they like to use the word inalienable. There's a reason they do that, because their authority is limited to positive law, man-made law. Same at the Supreme Court level, they won't touch unalienable unless it's already enumerated in the Constitution. But once it's enumerated in the Constitution, at that point it becomes an inalienable right.
So let me see if I understand this right.
All right.
An unalienable right is my right as a father, married father, with authority over my children.
Correct.
Yeah. Okay. Family courts take that away. That's against what God has given me.
Correct.
An inalienable right is my right to free speech, which did not come from God. That came from the government. Would you agree, or am I getting it wrong?
No, your right to free speech is unalienable. God gives you, he gave you the power of speech.
Okay, my right to bear arms, is that inalienable?
You have a right to self-defense. God gives you that right. That's an unalienable right. But
they can take away my gun and restrict my usage of that.
Only if you allow them. They take away your children too, and you allow that. Well, maybe you don't, but society does.
No, I did. Yeah. There's force. They will use force.
It's the fact that the Constitution and the Bill of Rights recognizes some of those rights as inalienable, but they are God-given. And the fact that the parental rights were never established or enumerated as unalienable or inalienable in the Constitution is where the door was, you might say, left open for those to undermine the family and family government itself. Where Blackstone called the marriage contract sui generis, a contract like no other because of the differences of the sexes. And that was pretty well understood in maybe the 17th century, 18th century, and maybe part of the 19th century, but that kind of language. He was under attack, as you can imagine, because of his, maybe we say, biblical foundations for his common law and understanding of common law. But that slowly slipped away.
Because family law was never a civil matter until like the 1500s.
Well,
it was always governed by the church.
Family law didn't exist as a field of law until the mid 20th century. Prior to that, it was domestic relations.
But after the Reformation in Germany, up until that time, marriages were registered or recorded in the church, the Catholic Church. They had authority over that. And then when the Lutherans came around, we don't want Catholics controlling that. So they put the recording of marriage under the state government, which then I think that's when the body of work of common law, which my point is, common law is all derived from canon law or church law or God's law, however you want to say that. It's evolved, and then English common law was further specialization. In the U.S., law really has its roots in English common law. Do I understand things right here?
Yes. Now, uh, see, getting back to this father's right to the custody under the common law, because it was a class-based system, and the heir apparent had a higher, or the father had more control over the heir apparent. In fact, his control over the child, his firstborn, I can't remember exactly, but it's longer than the children that he has under guardian by nurture. That was up until the age 14. At that time, the children were allowed to do basically whatever they want. The heir apparent was under the father's control till at least 21, and I think in some cases it went to 24, 25. So that heir apparent wasn't independent of his father until that point. But when that system came over to America, where we're not class-based, so we didn't have an heir apparent, all children were entitled to equal inheritance.
Not true. Not true.
All right.
That's primogeniture, primary right of inheritance of the firstborn, which is biblical. That existed in the North America up until the time of the Revolution. Then in the Declaration of Independence, I just jumped out at me last week, actually, all men are created equal. That's when Thomas Jefferson, who was the eldest son and inherited the bulk of his father's estate, then he said all men are created equal. So he abolished the right of the firstborn. That's what you were talking about. The firstborn, the heir apparent, was under the authority of his father for longer. And it was always a male. And then really with the institution of the United States of America, that's when that went away. And it was probably declining. The use was declining up until that time. I'll grant you that.
Okay, well, yeah, that's not going to disagree with that. In fact, I agree with it. I just didn't know that because I've read case law where the courts were trying to apply this guardian by nature authority in certain custody disputes, and they were having a hard time doing it because it didn't necessarily apply. And that's where the Flint case comes in, and that was in 1895.
You have a slide on that?
I thought I tried to load one. I don't know if it went through.
Min law? Is that what you're talking about?
Look, I'm scrolling through that. I think we had a reference to the Flint decision here. Slide 22.
Oh, well, we didn't really include too much on Flint. We didn't. I'm not. Well, what I can just explain what happened in Flint.
Okay.
This was a lawyer in St. Paul, Minnesota. He intermarried, meaning he married a Catholic woman. Intermarried at that time was understood to mean you married either outside your religion or outside your race, or you married outside your clan or your.
Mm-hmm.
Well, he was an atheist and she was a Catholic girl.
Right.
Purportedly married.
He explained to her that she did not want their children baptized in the Catholic Church until they were on their own and make that decision for themselves. Okay. And she understood that, and she went to the priest in St. Paul, and she had the child baptized against his consent, and the priest was aware of the husband's position. So it's a very interesting case as far as separation of church and state, or not church and state, but the separation of the spheres of authority between church government and state government. And then there was a big breakup. He basically told her, I'm not talking to you anymore. If you want to talk to me, talk to an intermediate person. And then she finally just left and took the child with her. And then he filed a writ of habeas corpus to have the child returned to him. And I won't go into the whole history of the habeas corpus corruption or how the civil law corrupted that common law writ. That's really not necessary here. But the court awarded custody to the mother by citing a provision of the probate code. And probate code is basically a guardian and ward. It's the the rules governing how guardian and ward relationships are established. And he cited this code, and cited the code, but the issue here involved this: Mr. Flint had this unalienable right to the custody, or as the judge in this case said, he had a statutory right, because even in the guardian and ward or the probate code, the father was given priority over the mother when a guardian needed to be established, a guardian other than the natural law guardian, which is the term we used for the paramount right of the father. Nobody else has coined that term.
When was this?
1895.
1895. The probate code was enacted in 1889. So 6 years later, the judge relies on a provision of this probate code to say that his legal rights under that statute aren't outside of his authority, that are beyond the control of the court. And his attorney was making an argument for this attorney that he had a natural right to the custody. But as soon as the argument got switched over to this probate statute, now they were arguing a completely different set of rules. So the judge was able to cite this statute and then say, well, it's not an absolute right, and therefore I'm going to award custody to the mother. And as far as I know, there was never an appeal on that, because it just died there. And from that decision in 1895, every proceeding court decision involving a custody dispute between a husband and wife relied on that decision.
Now, is that just for that state, or is that nationwide, or did it become nationwide?
But every state has a similar, well, I shouldn't say every state. I've seen several states that have a similar type process where they take this parent and child, this father and child, unalienable relationship, and convert it into a guardian and ward relationship. And just to make that even more clear, Blackstone described the husband and wife, parent and child, as private relationships. And private meaning civil government has no authority to interfere. And now, once you move into a guardian and ward proceeding, then the civil government has to be involved, because it goes beyond the authority of the natural law guardian, or it goes beyond the authority of natural law guardian, because now you're talking property interest, estates and things like that don't belong to him as an unalienable right. But he has this unalienable.
Yeah, I would interject here too. How it spread around the country. First, England already established its, if I get this correct, Child Infant Custody Act, where they made reforms in 1838 and some subsequent, where in custody disputes between husband and wife, children over the age of or under the age of 7 could be given to the mother upon petition for, if she wanted custody. This is the Carolyn Norton case. If you have heard of her, you can Google her. It's amazing how there's a woman who is well-spoken, written many books, and becomes very famous in part of that parliamentary debate, to where they cited women with this right to custody in these disputes in the home, involving a father who hasn't abrogated or abandoned his children at all. And then I think also the West Publishing is a St. Paul company, right across the street almost from the Supreme Court, you might say, and the in this Flint case in Minnesota, where Justice William Mitchell made this decision, and it's almost magically now finds itself in a book published by West Publishing. I forget the man's name. I've got it. I don't know if it was Madden or Peck, where this decision got what is it? This man wrote a book, or collected a book of notable decisions that were made in that, in Minnesota, and it got spread around the country because that book got published by West, and West Publishing is to this day has now been purchased by Thomson, and then Reuters purchased it just in the last 20, 30 years.
At the time, West Publishing was out of St. Paul, Minnesota.
Yep, but West
Publishing
now is. Go ahead.
Now
Steve.
it's known as Westlaw.
Correct.
Westlaw.
Right.
That's a good point. And so this books publishing these new cases and these innovative cases or cases of note got spread around the country that way. And that's how I think they named a law school after William Mitchell after this eventually. And I think it had a tremendous amount of quite a bit of influence. That's how this case spread around. But every state has a Flint-like decision.
Using a probate, which is not normative. Probates don't handle private domestic relations.
Nor do they have
with the death and the publishing of an estate. Now, the distribution of an estate and all that. With you have a executor of an estate, and they're the last will and testament usually, and then it goes to court a few times. You have testamentary letters, discovery of debts, and then you settle the estate.
But they wouldn't have jurisdiction over the child, the person, just property.
Right.
Because that was established under common law. The father had custody of the person, but not of the property, unless that property came from the father himself. If it came from an uncle, then they would need a guardian appointed to oversee that property.
So they use a probate code to, which has nothing to do essentially with what do you call it? We call them custody disputes. It's really a disruption of the authority of the head of household, the father. So they cite a probate code to make this extremely important fundamental change.
That's
right.
It's around the country. Okay.
It just
and Westlaw had.
Go ahead, Tom.
Westlaw had a hand in it because if you know that each state publishes their legislative enactments in their own volume, and then from there, Westlaw takes them and publishes into the Northwest Reporter in Minnesota and the Pacific Reporter out west. And what was interesting on the Flint case, and this is what really caught my attention and realized just how evil the system is. The original case has a footnote in it, and it's a footnote that directs the reader to this section of the probate code. And it also had a footnote that just referenced the citation. So it had two footnotes. but the primary one was the citation for the probate code provision. Now Westlaw takes it, they remove that citation for the probate provision, and they only have one footnote, and it's this other irrelevant, in my opinion, footnote. So if you only read the Northwest Reporter, you're not going to see the statute that this judge relied on to make his decision.
So there's a conspiracy involved.
That was definitely a conspiracy. It wasn't a typo. They knew what they were doing. And once I saw that, I said, this was a big case. I went down to the History Center in St. Paul, and I said, there's got to be newspaper clippings on this decision. And sure enough, both the Pioneer Press, the St. Paul Pioneer Press at the time, they published a couple of articles on it. And they also included other stories from other states. There was a case in Wisconsin and a case in Michigan that they reported on, and their caption was, both want the child. So this debate on the father's paramount right to custody was as big a case back then as our marriage and civil marriage or gay marriage case was this last decade. And it was through that I realized that, no, this is an important case and it was decided wrongly. And how do you fix it when you've got 100 years of case law based on this error or this deception or however you want to categorize it? Now, trying to restore this father's natural right would require undoing all this case law, all these statutes, because now statutes are being enacted under this premise that the best interest of the child is paramount, not the rights of the natural law guardian.
And it's just absolutely absurd.
We have a plan to advance that we realize it's not only difficult to put together, but it's going to be highly expensive because the only way it's going to get fixed. Well, I don't know if it can be fixed. I think our Supreme Court is too corrupt the courts are too corrupt. But you got to try. I mean, you got to advance God's word. And all I can do is show how God's word was concealed, hidden from us through this manipulation of statutory law.
So you would have to appeal up, and ultimately it would have to be decided by the U.S. Supreme Court, correct?
Correct.
Yes.
Well, no, it first has to be ruled on at the state level.
Right. That's what I mean. Appeal up, but you know where it's ultimately going to go.
But if we did it in federal,
we are talking domestic relations, and not, well, again, back to this definition of family law. Family law is a commingling of domestic relation law and child welfare legislation.
I'll add that back to the stage so they can see that.
Yeah. And there's another slide here. Did I get that to load? I guess
Arbitrary power, natural rights, Federalist paper.
No, I've got a slide somewhere that I couldn't load that explains or shows you in statutory language what they did. I don't know if you're familiar with it. No, but that's kind of an example of what they do to corrupt the law.
Okay.
This is a perfect example.
But this is an example. This includes both domestic relation and child welfare legislation. But it's in the context of a divorce proceeding, because there's a term here, support money, and then child support. Support money is Minnesota's term for a divorce where the man is at fault. And I would argue if the man is at fault in a divorce, he forfeits his natural law guardianship because he broke the contract of the marriage. And at that point, the natural law guardian would default to the mother. But in the context of this article, support money applies to a divorce. Child support is a term of art used by child welfare agencies. It's administrative law, in effect. Child support only applies to a dependent child in need of public support, or it can apply to a child who would be on public assistance without support money. So that support money can become child support if it was a divorce, the man was at fault, the mother's a natural law guardian, but now she surrenders that natural law guardianship when she applies for welfare. She's saying, I can't perform the functions and duties of a natural law guardian. I need public assistance to provide for my child. And at that point, she receives public assistance. The administrative agency, the welfare agency, then goes after the man who's owed support money. And maybe that's the reason she needs public assistance, because she's not getting that support money when he abandoned her or neglected her or whatever the cause for the divorce was. So if the state can then collect that support money, it gets converted into child support so that they can process it through their system, through the whole 4D child support program, if you're familiar with that.
Well, maybe it used to be that way, but when I was divorced in, I don't know, 2006 or 2007, no, there was no public support needed. But I was assigned child support under the same statutes, so they can put it under the same program, so they can show they're getting money from me and Title 4D matching funds to support their program. So I was not at fault. It was no fault. Yeah, she made accusations. They were baloney. But you know what? Everybody falls under this now. There's no need for a woman to say she would be on public assistance before the state steps in and imposes their draconian measures.
That's where the application for child support services comes in. Were you notified that she applied for child support services? No.
Well, it doesn't matter. The whole 4D program only applies to dependent children, and we have a Supreme Court case that says that. It's Sullivan v. Stroop. And in that case, they said that child support is a term of art that works in tandem with Title 4A, which is the benefit, the welfare benefit payment program. It's not a standalone. It's not a standalone program.
Yeah, designed to recover state money.
It would take me an hour to explain exactly how they manipulated the laws to make it appear as if it applies to everybody. But the law does not, when properly interpreted, allow for that.
Oh, I understand that. I'm just saying in practice, I don't think they follow the law.
Well, at this point, I don't think they know what the law is. Because this system has been corrupted for so long, for generations. And trying to restore God's natural order for family government, it can't be done under the current system or the way things are now. You're not going to get enough people to just say, well, no, we disagree. God says I'm the head of the family. But the civil law is going to override you unless you can show the error in the civil law.
I just want to point out something there's a similarity going on in the fight that's happening in the 2A community right now. They are having an enormous amount of trouble convincing the lower courts to pay attention to the verbiage used by the Supreme Court, because they play these verbal word games. And you're talking about corruption of the law. And I don't know, as a question to you guys, would that corruption be a corruption of the law per se, or a corruption of the language? Because we're like in the 2A world, we're seeing them argue, well, you should only ever have access to single shot muskets, right? Because that's what the founders had access to. You know, are we seeing something like that where they're literally twisting the meaning of words based on like modern understanding of old words?
Well, yes and no. They twist those words so that the general public thinks the law says, or convinces them that the law says something it doesn't. Again, like the musket thing. No, that's a false argument, because the purpose of the Second Amendment is self-protection. It has nothing to do with the type of self-protection you use. It's just saying the Constitution just says you can't take away a firearm as a means of self-protection, whether that's your individual protection or your family's protection or your community's protection or your nation's protection against enemies from within.
Yeah, they have to change these terms so they can apply a welfare Title 4D attached, to recover state money spent on dependent children. Well, what's a dependent child, and what's an absent parent? So if you look at Black's Law Dictionary under absent parent, you'll see it just notify, with an arrow going to non-custodial parent, using the two terms as if having the same meaning, but they're very distinct. Just like support money or child support, they use them interchangeably. When Title 4A of the Social Security Act had no, absent parent and dependent child had distinct meanings. And today they mean, well, whatever they want them to mean in order to establish a support order, because that's the money that feeds the court system. It seemed to me after they passed, aid to families with dependent children, AFDC, and then TANF, there was a tremendous amount of child support collected, and new courthouses sprung up across the country as a result of it. It's quite
the term absent parent originally applied to the 4D program when that was enacted in '74. Then after the Sullivan v. Stroop case, the federal agency, through their federal regulations, replaced absent parent with the term non-custodial parent, because Sullivan v. Stroop clearly stated what an absent parent was. Now, they just changed the terminology. They admit that in their own paperwork, that we're not changing anything in the law. We're just changing the terminology to make it sound like the father has, the father is spending time with the child. So he's not really absent. But by definition, an absent parent is one that is guilty of abandonment, neglect, or abuse. And therefore, and because of that, the mother of the children needed public assistance. And part of the service programs provided by that program was to track down this absent father and get him to fulfill his obligation under the divorce contract or divorce decree.
And this was the real welfare reform of the 60s, where they were seeking these absent parents to make them pay because of the increasing number of children born out of wedlock, for one.
Well, the Sullivan v. Stroop case was in, I think it came out in 1990 or 19, yeah, it would have been 1990. And that really shook up the administrative agency in DC. You can see that through their federal regulations and their just the discussions at the agency level. And I've looked at the presidential papers from 74 when the law was enacted. And President Carter called these absent parents runaway pappies. This is what's used in the official record. So that's what they were talking about, these men that had skipped out on their families and left them destitute in need of public assistance. Once
That's
they
not what
started
he's
using
dealing
the term
with.
non-custodial parent, they could apply that to everybody.
And
Because now they
and make you into a servant, SLAVE, of the state, a cash cow.
well, I think it was more the control. And, this child welfare legislation stuff, that's been run by females since the early 20s. The first female secretary was in charge of welfare.
Right, but there was a propaganda spin here, and you mentioned Carter when it was implemented, and all the conservative or Christians got on board because, yes, this is good. We need to make these fathers pay, not realizing that would be every man and that it would be contrived to control men. And even now, there's all this talk about deadbeat fathers, and they throw around that label so easily. Most men are not. And in fact, the ones that are typically don't make much money. So they can only be assigned child support of 100, 200 bucks a month. The state's really not that interested in collecting that because the matching funds they'll get from the federal government under Title 4D just don't fill their coffers. So, you know what? If you're a very poor man without a job, you're not going to be as controlled as a guy with a good job and a good career, upper middle class to upper middle class. You're the guy they're coming after. The good guy who is there and wants to be there for his children.
And well, on that, again, they're not supposed to be going after these good men. In fact, this is my view is now that women have so-called reached equality legally, there should be no need for child support. If she can support the child without the father, she should do so. In other words, the state should be telling her to go out and get a job, provide for that child. Because in a divorce situation, if the mother skips out, the father can't apply for welfare because the whole thing starts under aid to dependent children. And they didn't consider a child under the care of its natural law guardian dependent. It's only if the mother's a natural law guardian, it's only when she applies for public assistance that she loses that status. And she's no longer the natural law guardian. Most men would not apply for public assistance. They'd go out and get a job so that they can provide for their child. But the system makes it so easy for women to get this so-called free money. And of course, I'm sure you know that they started this whole program in the Black communities. And that's what broke up the Black families to the point where I don't know how you describe the point. They don't exist anymore unless they, yeah. I won't go into that. That's not my expertise. But getting back to this article that's up here, if you notice, it starts out an act relating to
Human services.
human services. What's human services? It's an administrative agency. So this only applies to people that fall within the jurisdiction of the administrative agency or the Department of Welfare, because that's what human services. Before that, it was the Department of Welfare, and they renamed this so many times. I liken that to the old German Enigma machine. Every day they would spin these dials so they get a different setting. Well, in the civil law, when they're about to be exposed for something, like in the uh, Sullivan's case, where this absent parent being directly connected to welfare money was, made general knowledge, and they changed the terms. They spun that wheel, and now you don't know what that term really means. You have no connection to non-custodial parent to the original term absent parent. But once you make that connection, and then you research, well, what's an absent parent? You find out that it's this runaway pappy that the law applies to. And they do that with all kinds of stuff. And again, on this one, um, it's because try and read that statute and make sense of it. So it's really kind of blurry, and I don't want to misstate it. Okay, it says support money, comma, child support. Support money or child support means, and then they give a definition. How do you interpret that? Why do they have two terms? Why don't they just say support means this? Because this is a statute that if you look at support money, it comes out not an act relating to human services. It begins with an act relating to domestic relations. Because that support money dates way back to territorial times, maybe not quite that far, but clearly at the time of the Flint decision. Support money was just a term they used when an award of money was given to the wife because the husband had skipped out or whatever.
When he breaches the marital contract, he's found, in a divorce. It's a legal action. And no fault divorce was simply replacing legal actions like a trial who breached the marital contract, and they changed it to proceedings. So it's just a mere proceeding now to dissolve a marriage. And so there can't be an award in a dissolution, in a proceeding where no party has breached the marital contract or been found guilty of it.
And now you're getting into a whole different area of what you need to understand to be able to interpret these statutes properly. But the key is the title, the enacting title. Because under Minnesota statute, by constitutional law, each bill has to apply to a single subject. Because of that, they started commingling domestic relations and child welfare legislation to create family law, and now they call family law a single subject. So now they can pass laws that they enact relating to family law. And what was the other recent one they did? Oh, yeah, the last thing I saw before I gave up on this whole thing 10 years ago was they passed an act that said an act relating to civil law. And I approached the legislator and I said, what's next? An act relating to law? What does that tell? That doesn't inform the public as to what the subject of that bill is. That's how corrupt. That's what I mean by corruption of the law.
Okay. So basically, they commingle different sets of laws with using a probate code, and then it gets published around. And then they keep reinventing terms, reinventing agencies to enact their tyrannical system contrary to basically the natural rights of a father or the natural law of father custody.
But keep in mind that it's not, these legislators don't know what's going on. They get handed bills by special interest groups drafted by clever lawyers that make sure that everything kind of slides together because they know where they're going in the future. They need to lay the groundwork today for where they want to be 5-10 years. It's like communist planning system. But here they have to do it by law. So they come up with clever ways of manipulating the law itself to read constitutionally. I would argue there's not many unconstitutional laws. They're just unconstitutionally applied. And if you're dealing with a 4D agency and paying child support to that agency, and your child isn't dependent, then there's something wrong. They've wrongly applied those statutes to you. And the judge doesn't know that. The judge is, because this thing has been corrupted for so long, the judge is just doing what the statute says. Oh, there's one other thing I've left out here. This title, an act relating to whatever, that gets stripped out when they compile it into their so-called revised statutes or whatever the state calls their compilation of laws. Those laws are so far removed from the title that when you read a section or a statute, you don't know what the enacting clause was. You don't know the subject matter of that clause without that title. And they've taken wide latitudes with that little trick there.
And it's made worse because most of the legislators have no clue how the law is even made and what the law even means when it's written. So they just vote yes or no as told by their party leadership. So you're really, when we go to the legislature to talk to them about these things, they just stare at you like you're like you're an alien. They have no idea what they're doing. And that's why they put people in certain positions of power so they can railroad them with all these changes. So you'll find a legislator, I'm against this and I'm for this, and they'll just vote whatever they're told anyway. And you call them on it and they get upset, but they don't care. No one reads how these laws are enacted and they don't really look into it. But there are some who know what they're doing for sure. And they're trying to cover up, especially the state agencies. They're making a lot of money on this. I know when I went to the state agency in St. Paul, and the guy asked me he wouldn't allow me beyond the lobby. And he's drilling me, who am I? Like I'm here to uncover the mass crimes you guys are committing and the theft. And they just don't want me anywhere near them. They just want to know who I am and who do I represent. They don't want to discuss anything about the law or what they're doing. It's quite amazing. But
this particular slide up here, this is one I actually went to a legislator with because they were proposing legislation that would have omitted support money. And I went in there and said, you can't remove support money from the context of this 518 chapter, which falls under domestic relations. But they merged the welfare legislation from 256, components of that, into the domestic relations. And they were trying to omit that because they knew that was kind of a problem. Once I went in there and I told them, well, you can't remove that because that is the domestic relation law. And you're talking about administrative law with child support. One is private, one is public. You can't mix the two together. Or no, I didn't say that. I said you can't remove this one, support money. And this is what they came up with. They put the two together with this gobbledygook. It makes no sense. You don't know what this statute talks about. Is it talking about child support or is it talking about support money? Because it means it's either this or that. And then who decides which one it is? The judge? Well, the judge is never going to side with support money because that can only be issued in a divorce. Child support can be issued in a dissolution. Because dissolution are proceedings, child support comes out of an action, and proceedings are more administrative in character as opposed to private in domestic relations.
So Steve, if you look at your final divorce decree, you'll see more than likely you're only going to see support money. You won't see the term child support in there.
No, he will only see child support. They don't use support money anymore.
I think it's only child support in there. I mean, I haven't looked at that one for a while, but
What year was this?
2007.
Yeah, it's child support only. They haven't used support money since probably the late 80s.
Yeah, see, mine had support money.
True.
Mine had support money in it, 1987.
Yeah. Because it was Sullivan v. Stroop that facilitated this change. Although this one didn't change until 93, 3 years later. But that's how long it takes for this stuff to ripple through down to the states, through the administrative agents.
Yeah, these cases challenging it, would have to be done, like I said, multiple states at the exact same time, working its way through the federal court. So we have the 5th Judicial District, the 8th Judicial District, the 9th, coming up with different answers to, well, the natural right argument, and even in this a child support case, or challenging the child support system itself. And these conflicts would definitely happen, and the Supreme Court would have to hold it. But we can't have an idiot, filing these lawsuits. We have to have someone who really knows what they're talking about here.
Well, okay, I got a question here.
All right.
This has gone on for so long, and there are a lot of lawyers, attorneys out there, and some of them are good men. Some of them are actually smart. Some of them understand this.
Really?
Maybe one or two. I mean,
Well,
yeah, that's
made to understand.
so. Why hasn't some attorney taken this as his life goal, maybe at the end of his career, to address this for altruistic reasons, for his legacy, to correct this? A good Christian lawyer. It's never happened. Why?
Because of the way it was implemented. That brings us to this slide, arbitrary power.
I'll pull it up.
This is why they've never won. And this dates back to the trial of Thomas Paine in 1792. Thomas Erskine was his attorney. But this is what he said about arbitrary power, and that's what we're claiming, this child support program being extended to all children, and the whole marriage disillusion over divorce. To me, that's arbitrary power. They've intruded upon the private domestic relations, the family government. That's what this arbitrary power has done. It intrudes, or at least in the context of today, civil government has invaded the sovereignty of family government. But it's because, but it follows the same structure, that they implement changes or they remove, he calls it, barriers and fences of the people's liberty must be picked up one by one. And some plausible pretense must be found for removing or hoodwinking one after another. And we can walk you through the history from Flint up to at least 2010. That's when I stopped looking at stuff, because I didn't need to go any further, because it's only getting worse. It's not going to get better until this is resolved. One after these centuries, who are posted by the Constitution of a free country for warning the people of their danger. In other words, nobody saw this happening. What happened in Flint went unnoticed. There wasn't an outrage, or at least I didn't see any news clippings after that. But there may have been. I think it was just as contested as the same-sex marriage issue last decade.
I think when they last saw it coming, you could see the Dabney article you guys had a talk on. And we have this Fairchild's book on the moral science where he describes family government. This was 1869 or thereabouts. And I found the Pope wrote a beautiful piece on the enemies of marriage in 1880, in which he identified communists as one and Mormons as another, enemies of marriage. And yet, after these changes through the Industrial Revolution, the two world wars, as you cited, it's long gone and defense of it. And the church, all the Christianity is, you might say, has a heretical understanding of marriage. They've abandoned it. And it's terrible. God isn't coming to save them. No way. Why would he? And that's where we're at. And we're claiming that to establish this unalienable right is going to take time. But if God be with us, who can be against us? That's the only point I make. And it's legally sound.
And getting back to your point about attorneys, why haven't they done this? Well, this explains, at least in my mind, why that happened. Because I've gone through, like I said, I've looked at probably every custody case involving this abuse of awarding custody to the non-natural law guardian. But what we need is a lawyer that will do what you just said. We need someone at the end of their career or even past their career. We don't actually, they have to be past their career, or not past it, but near the end. They have to be willing to give up their law license because they will lose it. And it's still not reach up to the Supreme Court, but our goal is to at least get this information out to the public in as powerful way as possible. I mean, how do you educate 330 million people that their parents and their grandparents have been deceived about what marriage is and what family government is and who the head of household is? That's why I'm fixated on this Flint case because lawyers do understand what I'm talking about. They do understand the title of a bill is important to the meaning of the law, but they just don't see it. I worked with an attorney by the name of Jack Graham, and it was kind of his paralegal for a battered women's suit that he brought back in 97. I can't remember what year was that, John?
I can't remember.
2000.
Was it that far? Was it 90s? It could have been the late 90s. Yeah, it must have been.
Well, but he filed a lawsuit claiming that the Battered Women's Act or Domestic Violence Act was unconstitutional because it only provided resources for women. And he was making a sex-based argument. And unfortunately, he didn't know what he was doing when he got down to the nitty-gritty of the case. It all came down to standing, like we saw in the 2020 election. Courts they're gonna kick it out for standing if they can. And he was making the argument that it doesn't matter how much a taxpayer has contributed to the funding of the statute, that they have standing to challenge it. When this lawyer could have had somebody that had been denied services under the battered women's shelters or whatever they were called, he was denied entry or services from that under this law that we were challenging. And the court just they twisted it through the proceeding up to the appellate level at the in the Eighth Circuit, and the Eighth Circuit said, no, what you're saying is ridiculous. If that's the case, anybody could challenge any law that spends public money. No, you have to have a harm. You have to be harmed by that statute before you have standing. And he could have done that, and he didn't do that. And I haven't talked to him much since, because we wasted 2 years on that case.
Well, there's been a time in history where the question about marriage itself is finally come from not just divorced men, but it's coming from men who have never married and rejecting marriage. This is amazing to me. I never would have dreamed this ever would have happened. We believe that this is a significant change in society.
Well, yeah, a lot of the young men are going on a modern marriage strike because uh, you get
Well,
fleeced by entering marriage, and the marriage is not even true marriage. It's
well,
this
they can't require
civil
natural law
marriage that you
guardianship.
just get destroyed. You just get destroyed in the end as a man most of the time. If the divorce, if there's dissolution proceedings or whatever you want to call it.
There are no divorces anymore. Well, no, that's not true. Some states do still provide divorce and dissolution. I don't know what they are offhand, but some states still allow for what they call religious or uh, sacramental marriages, things like that. So,
Well,
and
yes,
you do have to show law.
yes, okay. Man, I got divorced a second time in the state of North Dakota. North Dakota still has statutes for at fault divorce and no fault divorce. And I wanted to fight it and say, prove fault. My attorney would not do that.
Right.
I couldn't go down that path.
He didn't know how to present your case.
He didn't know how. No. And then furthermore, here's how messed up it is. I entered the marital residence. It was under her name, but it was a marital residence. And then the female district attorney decided to charge me with burglary. I cannot burglarize a house while it's joint marital property. Never mind that. And then I had to get another attorney, and that was a felony. So he pled it down to trespassing. So I trespassed, but I was never given notice that I shouldn't enter. Well, that's not trespass.
Yeah.
So they don't care. First of all, it should have been thrown out as a property matter. And I pointed that out to my attorney. But no, he's not going to argue that. Well, it was a female judge. So,
Yeah.
Judges don't have to follow the law. I understand. I still think it was wrong. The law was clearly on my side. Was it smart what I did? Probably not. And I'll admit to that. But was it illegal? No.
Well, that's what got me involved in the whole legal stuff. Is I had a lawn care business, and the state of Minnesota said I needed to get a license to apply chemicals I don't apply. Or if I didn't get the license to apply these toxic chemicals, these what they're called restricted use pesticides, I couldn't operate my business anymore. So I ended up just shutting down the business. I wasn't gonna.
Right.
I'm not going to get a license for something I don't do. And that went through. It went up to the Supreme Court of Minnesota just denied review, but the appellate court made a ruling, and yeah, they trashed the law. Because I did this pro se, and
Sure.
That's the problem of being pro se. They use pro ses to establish justification for their bad laws because we don't know all the nuances of the proceedings and the proper rules to follow. And so,
Right.
Yeah, I created bad law by challenging that I didn't need the license. But I wasn't going to get the license if I wasn't using that product. And I paid the consequence for that decision, but I'd do it again. Although this time I'd tried a little harder, a little smarter. Because I did have
you get beaten down, then you start learning.
Yeah, because this was brought by administrative agency, the Department of Agriculture, was who the bill was written to regulate. And my business was I was applying fertilizer and weed control products to commercial or residential lawns. and they used the term commercial applicator to hook me into the so-called, because, well, yeah, the license was either for restricted use or being a commercial applicator. And a commercial applicator, I now live in Morgan, Minnesota, in southwest Minnesota. A commercial applicator are the aerial planes that crop dust. They're the ones that pull the big semis full of tanks with the big spray bars behind them. Those are commercial applicators. And an administrative law judge agreed with me. But then the commissioner, because he's an administrative law judge, the commissioner had the power to just ignore what he said. And he did. And then it went up to the Court of Appeals, and they do what they do. They support whatever the agency says the law is. That's why this latest thing on Chevron, I don't know what it was, dealing with the administrative law rules. That was a really big case. Because I was a victim of that abuse of that system. But that's what got me into it. And once I learned what I did in that case, I had a friend that got a notice in the mail. He was in the process of getting a divorce. The 40 agency sends him a letter and says that his ex-wife had authorized their agency to collect child support. And the first thing I said to him is, where does she get the authority to authorize an administrative agency to do anything? And then he brought a battle challenging all that. We met up with the county, the head of the 40 agency in a meeting, and finally got her to recognize that there was a huge due process problem here. Because the police came in and kicked him out of his home, just on her say-so. And you compare that to what this topic of this El Salvadorian not getting due process. But here, he's kicked out of his home without any due process. It's just a cop with a gun says, you will leave. So he fought that for a while, and it was only over like a $50 a month support. But he got involved in it, and then from there we started an organization called Center for Parental Responsibility with a woman by the name of Molly Olson. Don't ever get involved with a woman leader in any organization.
Nick and I will both fully endorse that statement.
At one point, I finally said to her, because back then it was called the Father's Rights Movement or whatever. And I said, a woman is not going to ever lead or bring success to a father's right. It's not possible. And then she kind of started distancing herself and going off on this tangent of equal parenting. And I said, no, there's no such thing as equal parenting. There's either a natural law guardian or there isn't, and then it's a state ward. Without a natural law guardian, then the state has to step in somehow. Some states said that, well, at least when they were referring to this natural law guardianship position, they were using the term natural law or guardian by nature from the common law. And there were courts saying that, well, no, the grandfather or, a removed family member could assume that or guardian by nature authority, and they award custody on that basis. But they don't do that anymore because guardian by nature is obsolete. That's because I started this whole thing using the term guardian by nature because that was the only thing available to me in the law. There was no other description of this parental power.
Well, I think we've established that the law is wrong. It's not really based on anything just. It's contrived. The people who apply it, some of them are not so smart. Some of them are evil. Others don't really know how to do it. So what are men doing? John brought that up. Young men are avoiding marriage. They just are, Christian or not. The smarter ones are saying, no, I cannot get married and have the state assert authority over me because, yeah, the odds are it's a 50% failure rate or divorce rate, and 80% of the time the woman files, and 80% of the time when the woman files, the man is completely caught off guard. So young men are just not signing up. They may be shacking up with women. They may be having kids with women, although that's not that
That's
common
just as
anymore.
risky, if not worse.
Yeah,
Because these
well,
family laws,
So what if we take
all
it to the
family
church?
laws are based on dependent children.
okay. That's a good idea. Take it to the church. What church are you going to take it to?
I would go to the institutions, so the divinity schools where everybody becomes a minister, whether it's a Methodist, a Presbyterian, a Lutheran, a Roman Catholic. We want to go to Notre Dame. Where do you stand on civil marriage and this sacrifice of Baal? That's what civil marriage is. It's a marriage of heretics, according to Reverend Dabney. What else did he call them? Not just heretical.
Two-headed monster. Two-headed monster.
Yeah, but he called.
Vagrant concubinage.
Yeah, that's it. And whoever, what did he say about any Christian who believes in an egalitarian marriage is a blasphemer? Now the question is the Catholic Church changed? I don't think so. So Notre Dame, what are you teaching your priests? And what are your priests actually doing but marrying people into a civil marriage institution that is where the children are mere creatures of the state? And what you're doing is sacrificing humans to Baal, sacrificing them to death. It's ridiculous. In the name of what?
So, yeah, Notre Dame is a lost cause. Okay, write down this name.
But any divinity, make a
Yeah,
public.
okay. Before I give you what my thoughts are, there's another YouTuber. His name is Peter Helland, Helland. He's a very smart guy. He actually took a case to the Supreme Court because he was fired from his teaching job for privately reading a Bible in his classroom. So he talks about a lot of these things that we're talking about here. And watch his YouTube channel. He's Catholic, but he has a lot of Protestant type. He's kind of all over.
He knows about Deb. And he knows about
absolutely.
Yeah.
He's written about Deb.
Yeah.
Okay, so that's just advice to you. Now, here's my idea. I live in North Dakota. We are a state of about 750,000 people. We have a fairly conservative Republican background. We're way behind on the progressive movement. The Diocese of Fargo is one of the most conservative in the nation. Take that for what it's worth. It is pretty conservative, though. Compare it across the river, the Diocese of Crookston. Oh, man, out to lunch. So here's the thing. You get, and the Catholics are, I think, the way to go because they're approximately 50% of Christians. If you can get a smaller conservative state and get them, somewhat prominent local Catholic bishop on board with doing something, maybe not attacking it the way you guys want to, but a different law that allows a marriage type that is not governed by the state. And for instance, the Catholic Church has always been against prenuptial agreements. Okay, there's good reason for that, because it's planning for a divorce. But nobody knows what marriage is anymore. So is the Catholic Church against marriage agreements? What if you came up with a marriage agreement that says these are the duties of men and women? This is what I agree to as a man. This is what I agree to as a woman. This is where the custody lies. This is where the authority is. And this is what happens in the event of end of the marriage. Okay, that's primarily a marriage agreement. So can you implement something in a smaller state, and all you got to do is get it in one place, and then it can go there? Or you have created an enclave where smart people can move to escape the evils of the modern world. That's
North Dakota is one of 6 states that passed I think it was Idaho Memoriam, and it was a resolution in the North Dakota legislature to re-examine or take back or to overturn Obergefell. But I'd like to meet with the authors of that. They were threatened, as you might know, and they pulled back and voted it down in a subsequent legislative session.
The lives of the legislators, or they were receiving death threats.
I believe that.
Yeah.
Were you aware of that, Steve?
No, I wasn't, but I fully would expect something like that to happen, because they do not want any attack on this, any momentum.
It'd be nice to meet one of those. It would be nice to meet one of those who pushed it. I can't pronounce his name. He's a Republican. I don't know if he's a state senator or in the House. What was his name, Tom? Remember that? We couldn't pronounce it. I could look it up quick.
Yeah, look it up.
But getting to your point of going to the churches, what would prevent the woman from just going to the civil government? The civil government isn't going to recognize this church doctrine, or what am I trying to say here? They're not going to recognize what the church establishes as marriage, and they're not going to prevent either of the parties to go to the civil government and apply their laws against the marriage they established to the church. How would you separate? How do you keep the civil government out of that contract, that agreement? I don't know if that's possible.
Okay, you're right. That's a good question. Here's what I know. Historically, this is a Protestant nation. And the Catholics moved here, they were newcomers. They wanted to fit in. So the Catholic Church is obedient to the government and says, yeah, we're not going to marry you unless you have permission of the government. So a priest is not going to marry you without having the government involved, without a license. So basically, and in the Catholic Church, marriage is a sacrament. So we're letting the government be a gatekeeper to the sacrament. Okay, that's how it is. So we have to attack that gatekeeping role, first of all, to allow Catholics, priests, to marry somebody in a marriage, sacramental marriage, that's non-civil. And then, is there a way that, because women, no woman, when she's getting married, is planning on divorcing. At that point, is there a way to get her to sign a civilly binding document that gives custody, primary custody of the children to the man? Can she give up her rights at that point?
Yeah, theoretically, yes. But again, the state wouldn't necessarily have to recognize that. I think their response would be, well, the marriage contract is like no other contract. And so what you're talking about here is a contract outside of the civil system that in this, how do I put this? Well, maybe I don't have to put it because I have to back up your premise about that you need permission from civil government to marry in the church. That's really not the case. That's another one of these exceptions. The marriage license isn't permission to do something that is otherwise unlawful, which is the normal, everyday understanding of a license. It gives you permission to do something. And I just was working on this today. The marriage license at the civil level is really just a certification. It certifies that the two people, that there are no civil laws prohibiting their marriage. It's not a license to marry.
I understand and I agree, but I'm approaching it from a different standpoint. The discipline and rules within the Catholic Church, implemented by the bishop down to the priests, is an order saying the priest, or the understanding that you're not going to marry anybody unless they have that clearance by the state.
Right.
So it's a restriction on the priest, not on the people.
Right, because that priest has to be a registered, has to have permission from the state to perform the ceremonies.
Correct. So
With
that's
yes. And yeah, they should not need that, but without that, then you don't receive the civil benefits that the civil law or the gay couples have been arguing about for years. Well, I can't see my spouse in the hospital because the civil laws will impact their choices in life.
true enough, but the gay people got around that by having agreements before they were allowed to marry that were, I think they were mostly recognized.
Well, some states had civil unions, sure, before gay marriage.
Well, and
that's really what
inheritance rights. You could have inheritance rights, and you could have power of attorney rights and medical power of attorney rights outside of any civil union. You can just give those under legal contract. And if you have medical power of attorney, I don't know, would a hospital deny you the ability to talk to the person that you have medical power of attorney over?
No,
I mean,
they can't.
Yeah, I see where you're going, and I agree. I just trying to understand how the lawyers in the civil government would undermine that arrangement.
Well,
they will.
You know what? I'm just trying to get proposed ideas.
They might recognize the union and imply their laws regardless, is what he's saying. But there still might be a stopping power on the clergy if they didn't adhere to the state and they had their own, they governed it by their own documents. There'd be some stopping power, but I don't think it would work.
See, here's my thought process. Attacking the law, I look at that as a expensive, low probability of success. So I use my engineering mind. Oh, is there a workaround here? So I test the workarounds. Oh, how can I craft something that looks like what I want without running afoul of this? Now, is it perfect? No, I know it's not perfect, and it can be attacked or challenged. Absolutely. But if I have something innovative, they're going to have to come up with a contrivance to take me down, but it's a new area of law. And I gave them something out of left field that they don't quite know how to rubber stamp this and send it through. So I might
I'll
have a
tell you what.
chance at success.
In some states, maybe, but what they're doing right now, they're coming up with these common law marriages where if you're in residence for a year or 3 years, they're automatically going to consider you under a civil union, civil marriage, basically common law marriage.
Yeah, my state has that. And Steve, I think what Nick, and our guests are trying to say is that at the end of the day, you can come up with a contrivance, and yeah, you can, but you're just playing games at the edge with them. It's because the core problem I see here is it doesn't matter what the marriage says in most states about the children. They can go after the biological father regardless, right? So we can have a long conversation about marriage and how to solve that, but when you're working around the edges like that, at the end of the day, they can still come in and say, like Nick said, oh, this is just a common law marriage. Boom, you're married under our civil law. Same with the support payments, right? Well, it's your kid. You owe this mother money because our law says so, regardless of what the church says.
Okay.
So to my mind, I think the answer is a little different. And
so how can a man get full legal and physical custody of his kid the day they're born while he's still married?
I don't think he can right now. Not under the current system. And I think that's why you're seeing so many men just walk away and say, I'm not going to mess with this at all. They saw their parents get destroyed by this system, and they're just like, nah, I'm out. I ain't going to mess with these women. I ain't going to mess with marriage. I ain't going to have kids with these girls. Nothing. I'm out. They can't touch me if I don't play the game at all.
Well, my
Then they
view
want
on
to
that.
throw money to fix the birth rates. It's not going to work.
That's
My
right.
argument is once you're married and you have children, that father has the unalienable right. The problem is he doesn't know that. He doesn't know how to protect that. And there are ways to do it, or at least to make the argument that he has it. And I guess as the Family Government Institute, what we're proposing is to develop this, and what we need are some good legal writers, and then get it out on social media platforms and make this thing go viral and educate young men that they have this natural right under marriage. And also that the women have this natural right to coverture, which means she doesn't have to go out and work. Because I'm sure you've seen the videos about women in their 30s that started their career and now they're not with their kids, and they would do things different if they could go back and be a stay-at-home mom. That's what coverture provides them. But the feminists have twisted coverture into this wicked, evil master-slave relationship.
Well, coverture, women don't understand that. Well, does that mean I can't get my own credit card? Yeah. It means you have to spend your husband's money, and if you overspend, he's responsible. Well, I want to get my own credit card. Okay.
Well, that's what they've been programmed to do over the last 2 generations. But that's not what coverture is a benefit for women. And
I agree. They don't see it that way, though.
Just like men are coming to realize that marriage provides no benefit. because they don't acquire that natural law guardianship.
Correct.
Although it's theirs by natural law, by God's law, it's theirs. And they're not standing up and fighting against the state trying to deny they have that power.
Okay, so here's what I see in this, just listening in, is yes, they have the natural law. However, and a lot of men have seen this because they lived through it growing up, the state just comes in guns blazing and says and imposes what they want. So, like, I agree with you from a legal standpoint, but I think from a practical standpoint, men are looking at it going, yeah, but I have to go under the guns of the local police department to even get there. And but at the same time, you were talking about, we could educate women on coverture. That I think if you could make coverture great again, and then you're gonna have to explain to women that you're giving some stuff up for this. Here's it's a trade. Here's what you're getting in return. Then the dismantling of the feminist propaganda that has programmed us all to think this way is probably going to be more effective. It's a long-term strategy, but let's be honest, the guys are not lining up to wife these women. They're not. And they're not going to, so long as the state can say, well, it's because we said in this law that we can do this. And the guys are just be like, okay, fine, I just won't. Because the most effective strategy for the men is to simply not play the game at all. Like, I agree with what you're saying about the status of the law, but if you're a man, you're looking at it going, collectively, yes, we might be able to stand up to the state, but individually, I'm going to be subject to, swatting, getting the SWAT team called on me.
What about back to the
what-
churches? Taking the argument to the churches where we won't participate in your church or even go to your church if you accept this civil marriage institution in violation of God's law.
Well,
and make us,
here's the
and
problem, John.
yes.
That requires education.
Well, that's
And
Family Government Institute.
okay. Yeah. Here's reality. I think you're only going to be able to educate at most 10%, and that's a high number. Because first of all, most people don't care. They don't have the background, they can't understand. They're not intelligent enough to go here. So, yeah, you're not going to get a low percentage of men.
Well, the Second
And
Amendment
educating women is going to be tenfold less. To educate women, okay, the nature of men and women follow, men lead. To educate women outside of the common beliefs is an total exercise in futility. And most men, you can tell them one thing. You've had friends and they come to you with their problems and you say, oh, bingo, 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 do this. And then you talk to them a week later and they've done nothing. And then 6 months later, they're having the same problems.
I agree. That is a difficulty. I think biblically it only takes 3%.
Okay, well, that's your goal then, 3%.
So go ahead, Nick. I have a view.
All I was going to say is our whole point on part of this channel is we're for men. We want men to succeed. We want men to have potentially good marriages, but we also give them, here's the reality you're up against. But you have to try anyways. If you do nothing, then you accomplish nothing.
Yeah, our position too.
So,
because even if men avoid marriage, they're still going to end up having sex. They're going to produce children. The same laws are going to come down on them. They're not going to escape this system by not getting married.
Oh, that I agree with, but look at, I mean, birth rates have been in the news. Trump saying, "Oh, we've got to give out $5,000 to, get people to have kids," and I have gone on and on Twitter with people who do not understand that this is. They think, "Oh yeah, $5,000, people have more kids, will solve the problem, everything will be great." They don't understand that this is what we're actually fighting with. And you were talking about going to the church. Okay, you could probably take it to a guy like Pastor Joel Webben, okay, and he would probably take this and he would go, "Yes, let's run with it." But as a commenter down here, a regular viewer of ours says, most pastors and elders at churches, they aren't going to go with this. They are the church is dominated by women. The women pay the bulk of the tithes, and if they like, even pastors in the OPC or the PCA, some pretty hardcore conservative pastors. I listened to one at my old church where he had to, and you could hear him doing it in the sermon. It was a sermon on adultery, and he was sitting there pulling his punches when it came to the women. Oh, he went hard on porn. He went hard on all the traditional male sins, but when it came time to talk about female sin, nope, can't talk about that. And this dude's pretty conservative, and he just wouldn't go there. So I don't think the church is salvageable in its present form. So, like, I'm not saying don't go there. Talk to Pastor Joel Webben if you guys can.
Yeah, well, you describe perfectly what every minister I meet virtually says, unless they're retired and old. But I've never met one that won't back down. They're cowards, and churches deserve to be torn asunder. And
they're a business first and foremost.
God will allow it because they won't stand for him. See, that minister is going to stand before God and explain how he backpedaled on Scripture.
Sure.
Yeah. Yes, but
he's damned.
For him, that's a theoretical future problem. He's got to keep the lights on today, right?
I want to let him know he's damned if I meet him.
Hey,
he's damned.
You are talking. You're probably talking to a couple of them right now, based on who's watching.
Well, they're damned, and that's unfortunate. But I just, it's the truth. That's the beauty of the Bible. It just speaks the truth, and it cuts deep. And I don't know what to say. I know when I confronted one man who wanted to meet with me again, and so he set up a meeting because he asked me how much money I needed, and I said $10 million, and he never blinked. But the next meeting, he didn't show. And the minister of that church called me and said he was dead. That's why he didn't show. After he didn't show up. When I met another prominent man who stood, I stand on the Bible and I stand on the Constitution, he was humiliated publicly and never to be seen from again. I know what happens to these men when they backpedal. They can't claim they stand on the Bible as a judge, and they can't make that claim after they divorced hundreds of people in their days as a district court judge. They're damned. I want to let them know it, and I want to go for them.
Well, you're not going to find any disagreement here on this channel.
No. Well, because see, that's kind of how I stumbled on you guys. I knew you knew the truth. And that's the
So who's worse? The women judges who rubber stamp every divorce, or the male judges who go along with it and do the same damn thing?
Well, it's a nice paycheck in retirement. But what working man has a paid retirement like a district court judge does? 20 years in the system, 10 years in the system. Their pension is unbelievable. I just, I kind of pray the country goes bankrupt and they lose everything. And I'll be coming I'll be coming to their homes to collect what's left.
There's we've talked about the way this is going, our country is going. At some point, we're just not going to have the money. And yes, the third rail of politics, Social Security, it will be touched. But what's the first thing they're going to touch? Think Title 4D, because that goes to counties, not to individuals. So, yeah, okay, when that money evaporates, all of a sudden, this whole thing changes. And there's going to be wailing and gnashing of teeth in these child support officers in the whole court system. Yeah, we're going there. And then when there's been other people, I'm not advocating this, but we've mentioned this, the night of the long knives.
Steve,
yeah,
I've seen other people
you take it
using. Well, I've seen other people using that phraseology now, the night of the long knives, on Twitter, in regards to what's going on in this country. Now, they were more on the H-1B side of the debate because I've been heavily involved in that as well. But so I do a lot of finance and analysis type stuff on this channel, and I can tell you guys right now that personally, from a finance standpoint, I am watching 2029 with a very, very close eye. Could be 29. 2020.
Is that after Trump?
Yes, it's after Trump. And it's not because of it's not because it's after Trump. It's actually more about where the finance system will be in 4 years.
Yeah,
Right?
I get it.
So because there's one of the other big things I study is demographics. And 2029 is an interesting year because from a demographic standpoint, that is the year of peak boomer deaths. So the average age of an American lives to is 79 and a half years.
Oh, wait a minute. You're getting close to me now.
I know. I know. Hey,
Time's running out.
my dad is up there with you guys, and I love that man to death. So, you know, I know that what I'm saying is hard, and plenty of men will live longer than that. But from a financial standpoint,
but it's 29.
It's 29. And so, you know, dead people don't need houses. Dead people don't need cars. They get a 6-foot square plot of land somewhere, right? And so from a finance standpoint, you are going to be looking at a deluge of housing supply and demand. What is that going to do to house prices? Okay. How do most local governments actually make their money? Property taxes. When property values get whacked in half and stay down for years, the money that funds all these exorbitant programs dries up.
Yeah, there's families that make money now. I mean, I see them. Through fees.
Yeah.
That's interesting. 29.
We are already.
You disagree with that, but I do know.
We're already in a recession.
Yes, we are.
Already.
Yes.
Okay. Who is losing their jobs? Men or women? Oh, it's predominantly women. Okay. And you know what? Young women are in college. You know, if she's under 30, she's unlikely to be married. If she's over 30, there's a good chance she's divorced. Okay. And you know what? To keep the wheels turning as long as possible, it's going to be the productive people that stay employed. So that's primarily men. A lot of men are going to lose their jobs, but a lot more women. Now these women without men to rely on, who got cash and prizes when they divorced, guess what? They got to pay the pink tax. What's the pink tax? Oh, the toilet is plugged. I don't have a man to unplug it. Guess I better call the plumber. Oh, I got a broken window pane. Oh, guess I better call the carpenter. Oh, my car needs a new battery. Oh, I guess I better take it to the dealership to have a new battery put in it. The paint techs. Everything they do that's normally the job of a man is going to cost them through the nose. So women, this whole thing is such a house of cards, our whole society, that yeah, okay. I mean, I'm all supportive of what you guys want to do, but your plan is probably going to take 10 years. I don't think we have that amount of
At
time.
least, yeah.
At
And if we
least
don't have that, we don't have
I
that.
don't disagree at all.
Yeah.
Well, what I would
But
offer
one
up
thing
as,
that kept our economy going the way it was is this easy divorce. What does that create?
Right.
It creates
Yeah.
a need for two homes. And this is what the bankers, the people that are hiring the lawyers to write the laws the way they write them so that it can be misapplied. That's how they keep the funding going.
I
What
mean,
happens if the stock market drops in half and housing prices drop in half? Where's the money going to come from to feed the divorce system?
it goes away. Well, and so what I would say is, yeah, what you guys are probably right about your 10-year thing. I won't question that. All I would say is you cannot hurt anything by getting started and going. The more support there is for men, the more information that gets out there, the more likely look the collapse is coming. There's just nothing we can do about that. This is more about figuring out who gets a seat at the table to determine what the recovery looks like, what the rebuild looks like.
And that's one of our focus is when this system does come down, I think natural law will reinstitute the man as the natural law guardian or whatever they want to call it at that point. But the men will take leadership or they will die.
Yep.
Sure enough. I want to encourage you guys because you came on our YouTube channel. You know, how many subscribers do we have now? Are we up to 95 yet?
Oh no, we're not.
Oh, I saw a couple over near 200.
No, we get two.
Maybe
We
I'm
might
wrong on
get.
that. Maybe that was
No.
visitors. I don't know.
We got under 100 subscribers. We don't get that many views, but you know what? We got some key people listening to us, who are more influential than us, and our ideas might be percolating out there, or we might be just talking about things that are pertinent at the time, and the ideas come up all over the time. So there's a groundswell of underlying discussions about these topics. So
I think so
the
too.
two of you will have your greatest success in furthering the dialogue, not in whether you win or lose.
Correct.
But it's just you know, more and more people are talking about these things. And now Jordan Peterson, just in the last couple of days, came out against the woke right. And basically talking about conservative ideologues who are pushing agendas. I think it's a chance to marginalize this man, basically, because I think he's working for the wrong side. But no, we just need to keep pushing the discussion.
Yeah.
And I also want to encourage you guys. You guys have a long road ahead of you. Will it work? I don't know. I think you have a strong legal case if you can get the right person and the right money behind it. But it reminds me of this quote. I think one of you might. It's the Edmund Burke quote. Y'all know what it is?
I'm sure I've heard it. Bring it. Bring it.
The only thing necessary for the triumph of evil is for good men to do nothing.
Very familiar with that one.
That's my Twitter handle.
Oh, okay.
It's in my Twitter description. Thanks, Nick. That's beautiful, and that's exactly what it
I
is.
know. Well, once you see the evil, you have to do something to resist it. That's my
Or you
style.
do what most people do and you succumb to it.
Well, I can't do that. I wish I could.
Yeah.
Life
Some
would
of
be
us,
so much easier.
yes, life would be easier, but some of us can't. I mean, that's why we're here.
Yeah, I believe that. That's why I'm here. You guys,
That's how I found you.
we have like minds in certain areas, and
Well, that's how this stuff moves. There is a cycle to these things. What's the old saying? Weak men create hard times create,
great.
strong men. Strong men create good times create weak men. That's we're in we're in the weak men phase. We're at the end of it, and we're entering the hard times phase.
I agree.
And
Yep.
I guess our goal is to, when those hard times come, to have enough, large enough voice to instruct men on what it is they need to do as head of household, head of family, and their duty to protect them, that family unit that they establish, that they run, that they govern, protecting them from outside. In a collapse situation, it's not going to be civil government. It's going to be these rogue bandits or whatever. You're back to like Mad Max and that kind of scenario. It's highly possible.
I
But
mean,
if men don't understand what real marriage is, that they have this right by marriage, and when the collapse comes, I don't know what they'll do.
I think
Well,
most men will actually revert to natural law, whether they understand that that's what they're doing or not. Because one of the great myths that has been pushed, particularly by the structuralists, the French structuralists, is this idea that you can just edit reality by editing language. I mean, you see it in the law, but you see it elsewhere too.
Oh yeah.
Right. And so, but there's all this problem, and this has been tried before. The sophists tried it as well back in ancient Greece. And at some point, what will happen is reality reasserts itself, and natural law is an expression of reality. So if things get that bad, that now I don't personally think that we're going to see a total governmental collapse of the United States. That's a whole nother episode that we've done parts of it elsewhere. So, but remember, if we're talking about even just gutting the money stream and saying, oh yeah, we're going to take away half of the income of the state government. Now the state has to get really picky about what it chooses to do, right? And all of a sudden there's all these things it can't do. Well, individual men are going to have to step up and replace those things in their family units and lives.
So
and that may be enough.
I want to relate a story I heard. Well, a guy I follow, E. Michael Jones. He's written a lot of books. Smart Catholic guy. He's written on many topics. He tells a story. He visited Occupy Wall Street because, they had some good points. And he said when he visited them, okay, there are protests and, the cops were against him. What happened in that when you kind of go outside of the law? Gee, he said the men were out protesting and the women all affiliated with one man and stayed home and tended the tent and cooked the food and washed the clothes. It just quickly went back to natural roles.
A natural order.
All that natural law.
Yeah, hey Steve, there was another example, even more recent. You don't know if you guys remember the Chaz Chop thing up in Seattle?
Yeah. What happened there?
Oh, so I mean, this is liberal downtown Seattle, right? The women decided that they were going to get together and start planting crops in the middle of a park. And the men were the ones out because they barricaded a bunch of the streets. The men were the ones out on the barricades, and the women were cooking for them in the middle of the park and trying to grow food. Now they didn't know what they were doing, and it was really kind of comical. But there, this you can see how this is going to play out in these localized situations.
I always thought you could get 100 men to go down to the courthouse when times are rough for the county, for example, and just say, you're just not going to do this anymore. We're putting an end to it. We got to deal with these other issues, Judge. We got to do these other things. But this no fault dissolution, it's over. We're not tolerating.
That sounds like the sheriff's sales in the 30s.
Yeah.
Well, Steve, that's a good point. You need something else bigger to provide cover so that the cops don't immediately just round you up and kick you out. So, like, if you try and go
for those people who don't know, okay, in the 30s there was foreclosures on farms. So the bank would foreclose, and there'd be a sheriff's sale. We're going to sell this property. So all the neighbor farmers, probably 100 men, all came. And you know what? They told anybody who was planning on bidding on that property, yeah, you better not. And so, there was only one bidder on the property. And it was the guy who originally owned it, and it was taken over by the sheriff's sale. Basically bought his property for pennies on the dollar because good men stood up and said, no, we're not allowing this.
Yeah, I from a tactical standpoint, I wouldn't do that right now because the police the police has enough to suppress it, right? They have enough energy. They have enough bandwidth. That's why I was saying you need something else, something bigger.
Well, if half the police force have been divorced, you got half of them on your side already.
Those guys are still all assholes, if you ask me.
Well, actually, I'm not going to go that far, but the people on the police force tend to be true believers in terms of the law. So I don't know that you get half of them, but fracturing the police force would have to be a prerequisite to doing this. That's what I'm saying. I don't think you could do it right now, but let's say 2029, you've got all this economic chaos going on. There's probably going to be an uptick in violent crime. The police are stretched thin. Then you can start to say, and by the way, what I'm saying is not anything YouTube gods, right? The left does this all the time. That's actually how they got the Chaz Chop thing set up. They evicted the police station. And then because there was a police station right there, they evicted them and then they took over.
There are good cops out there, and one guy I didn't know who's divorced saved me from problems because he warned me, because he was looking out for me. But we also did a program. I led a program, The Color of Law Fair. How the police do this. Yeah, they're not so smart, those guys. They're not all bad. But you know what? They pissed off a lot of men, arrested a lot of good men, kicked them out of their homes. And so are these guys going to come rushing to the aid of the police if times get tough? Not necessarily. So, but they'll wake up, but they'll walk off the job, or they'll change sides or whatever. So, you know what? Yeah, they might come around. But right now, if you're going to deal with the police, chances are there might be two of them. One of them is going to be a royal asshole, and you're not going to stand a chance. And then they'll lie in court about it. Absolutely, they will lie.
Oh, that's true.
Yeah, there was actually a Supreme Court decision about that. It is okay for the police to lie in court. I'd have to go dig it up. I don't remember which one it was. It was, and it was actually, I do know it was reaffirmed recently. It was,
Yeah, I saw it in the news.
yeah. You guys know which one I'm talking about. I'd have to go dig it up. I didn't think I'd have to dig it up for this show. So,
So guys, was there any other points that we didn't get to that you guys wanted to address? Because we're about 2 hours, 10 minutes in. I just want to see if there's anything you guys wanted to address that we didn't cover yet.
Well, there's a whole lot more, but again, the idea here is to just get this information out there for men to realize that they do have these rights and they're being taken from them. And what they do about that after that is up to them. But right now, at least I don't believe that they understand what their rights are. They don't understand that this head of household, this natural law guardianship that we talk about, is something they get from God. And the state can't take it away from them. And just get that to as many men as possible and let them do what they will with it.
I like that idea. I think as an education strategy, particularly early on for the next few years, that's going to be the most impactful.
Yeah, well, it's all we got.
Yep.
God's in control.
I think this has been a good discussion. I love discussions like this because we're talking about a pertinent issue.
Well, thank you,
And
guys.
we're not all in agreement, but we have the same motivation. And you know what? We're not like a lot of men. I'm going to quote Winston Churchill. Men occasionally stumble over the truth, but most of them pick themselves up and hurry off as if nothing had happened. I don't think we're of that type. So I want to remind people that this is a matter of hierarchy. Men have greater responsibility than women, and they also have greater authority. So the kernel of thought is that, and that is a message that has to come from the pastors of the churches. And then this message, what you guys are doing is more detailed. Why, what, how does it work? But first of all, men have to realize, yes, you do have more responsibility, and yes, you have the authority, and yes, this is God's plan. And pastors, just start putting that message out there.
Yeah, thank you, guys. Really appreciate it.
Oh, it's a very interesting and informative conversation.
You guys brought a lot of legal facts and dates that was blowing my mind for a moment. I was like, oh, I knew some of them. Then you kept bringing them up. I was like, oh, okay. So you guys know your legal research, and I applaud you for that. I know you're not lawyers, so this is in no way attorney advice to our listeners.
If we were lawyers, we wouldn't be here.
Yeah, my father told me once, John, you should get your law degree and become a lawyer. And I said, no, Dad, I want to go to heaven.
All right. Oh, it was really good talking to you guys.
Stick around after the stream closes. We usually talk a bit afterwards.
All right.
Yep. Yeah, it was good chat with y'all.
Was what? Yes, great. I'd like to get.
So John and sorry, I can't remember your name. Tom. John and Tom. Okay. If you have any social media information that you want to share, you can go ahead and shout it out now, and we can update the description of this with that if you send it to me. So,
well, as I mentioned earlier, I haven't entered a single social media post.
Smart man.
Yeah, and I'm still waiting on the IRS, and then things can take off from there. In which I'll be looking for help.
Okay.
Because I can do.
Well, we can talk to you again.
That'd be
There's
great.
other guys you should talk to. Shaw. Yeah, this is Shaw.
Yeah, I know. I know of him.
Okay. And Dr. Stephen Baskerville. He's also a good
He's a friend.
source. Okay.
Yeah, we've been trying to.
It seems like you're traveling in good circles then.
Well, I hope so. It needs to get out there. Things need to change, whether it's through a economic depression or reset or whatever is coming down. I agree, something big is coming down. That our way of life is going to be changing. And what form that takes, it's up to God and time to lay that out or expose it. All I know is this is all I know, and I want to pass it on to others.
Well, we're here to share. We're here to help. So
Appreciate it. Again, appreciate it.
all right, everyone. So if you guys enjoyed the stream, give it a like. If you have a comment, you can drop it under the video. If it's a comment for our guests, we will try to forward it to them. Nick has their contact info. And so next week we are going to be doing it'll be our 1-year anniversary of streaming, and we are going to be doing a stream on the importance of morality, and specifically the importance of morality to systems of human systems. So we've done streams on morality before. We're going to do this one again. I've got some new things that I'd like to share. I'm sure Nick has a giant stack of notes for this one. So we don't really have a leader, but it's going to be it's probably going to be a long one, and it's going to be philosophical. I can tell you that right now. So it'll be a dry one as well. Bring your favorite beverages to
They always say we're dry.
yeah. So
We like it that way. So
well, that's why I think I called us the autistic nerds of the red pill. So with that, we will see y'all next week. Bye.